I now have the pleasure of introducing our provincial chancellor, Scott Ward, who's going to lead us through a basic overview of what it means to try a case, an ecclesiastical disciplinary case under Title IV of our canons. Scott Ward leads the litigation practice group and the religious liberties practice group at Gammon and Grange in McLean, Virginia, and his practice focuses on religious and other nonprofit organizations, constitutional law, employment, and child abuse prevention and response. He currently serves as Chancellor of the Anglican Church in North America, together with Jeff Garrity and Mike Donison, and also serves as the Chancellor of the ACNA Diocese of the Mid-Atlantic and of the Falls Church Anglican. But in his characteristic humility, Scott has failed to mention that he is licensed to practice in numerous courts in the states of California and Virginia and before the US Supreme Court, as well as various appellate courts, federal. If you go to Gammon and Grange and look at his biography, you'll see 3 pages of publications that he's written on these kinds of topics. And then on top of that, he's a San Francisco native and a fellow 49ers fan with me. So he's one of my dearest friends. And I just am deeply appreciative of all that Scott and our chancellors do. So Scott, I'm going to turn it over to you and thank you for being with us today.
Well, thank you very much, Phil, and thank you all for being here. It's a real privilege just to be in this good company. So many of you have been role models and partners, brothers and sisters at arms, so it's great to be here. I've been asked to, in about 12 to 13 minutes, give you an overview of the entire Title IV disciplinary process, which is probably a greater undertaking than is possible in that time or more time, but let's jump in and see what we can cover for ground. Let me start by just outlining a few things that I think I'll try and touch on. I want us to think about what are the primary principles in this process. I want us to take a little look at an overview, but then I want us to drill down in a couple of key points where there are particular vulnerabilities and opportunities. A part of that will involve thinking about who's involved in this process and what position do they play. And then we can kind of go through the process very briefly, and hopefully that'll set up the good panel that we have coming up at the end of this brief presentation. I do want to underscore, though, throughout this entire process, I think the challenge for all of us is to be persistent and faithful in prayer. We believe as a foundational principle that God is true, that God is alive, that God is active, and we should be inviting the Lord into this process and praying that His Holy Spirit would guide us as we go about dealing with these challenging situations. So let me jump in a little bit on the key foundational aspects of the process. When you're dealing with Title IV, it's important to begin with the language, the text of Title IV, and of your diocesan canons. That's going to be controlling. I was part of the drafting team for Title IV in 2009, along with Hugo Blankenship, who's with us, Wick Stevens, and Bishop Guernsey, who's also with us. Having been in that process, there are still aspects of it that we only discover when we try to apply it to a particular situation. So recurrence to the text is critical. The other thing that you'll want to look at are your ecclesiastical trial court rules of procedure. And I'll note at times dioceses run into situations where the rules are not yet fully formed, and yet they're staring down a possible disciplinary matter. So if your procedures are not already in place and written, this is the moment. Don't waste another second getting that in place. And then as you think about the process on the front end, I always find it helpful to be asking the questions of what legal privileges might apply and using that as a framing for what I'm doing. The clergy penitent privilege is often highly relevant. Obviously, the attorney-client privilege may be relevant as well. But foundational in this process are, of course, the scriptures, the faith once delivered to the saints, and particularly as embodied in some of the marvelous aspects of our Anglican tradition. And then, as my fellow Chancellor Jeff Garrity is always good to remind us of, the purpose of discipline, the nature of discipline in the church is stated in Canon 1 of Title 4. And that's to establish processes and penalties that are essential for repentance, reformation, and ecclesiastical discipline and order. So let's launch into a little bit, just a brief overview of the process. And I would suggest the process always starts with information that may or may not constitute an accusation under the canons. And that's a critical distinction. That information may trigger either the formal accusation process, but it often is information that triggers a preliminary investigative process that may then lead into the Title IV process. And if you don't ask those questions at the beginning, you may find that you're in the middle of something and you're in the middle of the wrong thing, or you're at the wrong place. Once there's an accusation, then you move into the process of a canonical investigation. That investigation is designed to determine should there be a presentment, a charging document or not. And then if there is that process of presentment and charging document, that puts you in an ecclesiastical trial court setting, which then leads to exoneration or sentencing, and then of course possibilities of appeal. And something that's been very helpful to me in thinking about this process was prepared a year or two ago by our fellow Chancellor Jeff Garrity, who has this marvelous flowchart that we will make available to all of you, but I've chosen selections from it that kind of summarizes the process. And as you can see, it begins with a call. The Chancellor, the lawyer, gets a phone call, and that call then has you triaging it to determine, is this serious enough that it might be presentable, or is it something else? Is it misunderstanding? Is it a situation for peacemaking? If it is serious, then you have to ask the question, where does it go? If it is at the level of an accusation, you're going to start that process. That's down in the very bottom right corner there. But if it isn't yet presentable or worthy of investigation, it may still trigger a need for episcopal discipline, for the bishop to pursue a process. Now let me flag just a few of the things I like to think about on the front end. When you have the process beginning with the accusation, you ask the question, has an accusation met the minimum standards for Title IV? And that means that it must be in writing, it must be brought by someone who can bring it, and it must be brought against a presbyter or deacon or bishop. Now, you may want to think at this moment, what might happen before we reach the level of the written accusation? Because not every report is an accusation. So sometimes you receive credible information and it triggers the bishop undertaking an investigation. Sometimes it triggers a legal obligation. For example, an accusation or a report or a phone call might immediately trigger a child abuse reporting obligation under state law, even if it hasn't yet triggered the Title IV process. So you want to think about that on the front end when you receive that initial information. You want to know where you are in the process, where you're not. You want to think about what are your timeframes that may apply. And you want to think about what's your purpose in this stage? What are you doing here? And how does this play into the end game? The reason for that is it's critical to know what hats everyone's wearing. And Title IV lays out a number of different hats. So if you think about it, the whole process is about the church, it's about the clergy, and it's about those the clergy are shepherding. That's kind of foundational. The primary people in this process are the bishop, because the bishop is usually the focal point of information about a priest that may require discipline. The bishop also, at the end, steps into the role of sentencer. And if you look at the ACNA canons, one of the important adjustments that's been made more recently involves in Canon 3 of Title IV, the possibility for the bishop, if he cannot fairly assess the situation, to delegate the process to another bishop. That may be invaluable in those instances where the bishop may have personal relationships with those who are involved. You also have a role for the diocesan or the ecclesiastical authority if the bishop is absent. Now, as you go deeper into the process, you have legal roles that we play. And one is, of course, your role as a diocesan chancellor, where you provide advice. The other is the role of a canonical investigator, where if you reach the stage that it is an accusation, under Title IV, you appoint an investigator to then essentially do the process that would be equivalent to a grand jury in a criminal proceeding of finding enough information to determine whether there's a presentment, whether there's an indictable offense. And then, of course, throughout the process, you have the accusers and the accused who are bringing these matters forward. Now, when you reach the stage where the investigation is concluding, that's where you have the critical question of, will there be a presentment? And at that phase, you have a couple of other players enter the game. You have the drafter of the presentment who puts it together. This is Canon 4, Canon 3, Title 4, Canon 3, Section 4, subsection 2, and then the signer of the presentment on behalf of the diocesan authority. At the point at which a presentment has occurred, you're now entering the trial process. And so at that point, you're going to have counsel appointed for the accused, and you're going to have counsel for the presenters, also provided for in Title IV of our canons. So if we go to Jeff's very helpful diagram, you can see that the accusation has led to an assessment. Is it credible or is it not credible, meaning completely without merit? And then let me scan forward a little bit. If it's determined to be credible, that launches the investigation. If it's determined to be not credible, to be without merit, so that's a very low threshold that it fails to meet, then it is possible for the bishop or episcopal authority to decline to proceed, but that permits the accusers to take an appeal to the standing committee and to determine, will they essentially second guess or overrule the bishop's process. Let me move us back to the right of the diagram. We've done the investigation. We've now reached the level where there's a report, a presentment, and a trial. So of course, at the trial stage, that's where the diocesan trial court or ecclesiastical trial court takes over the matter. That's where the rules of procedure come into play. If there is no diocesan trial court, Title IV allows this to proceed in the court of extraordinary jurisdiction that's established at a provincial level. If the accusation involves a bishop, it's the court for the trial of a bishop. And then, of course, there's always the possibility of an appeal eventually to the provincial tribunal. So you'll notice we're now in the phase of the diagram that talks about the trial. There are three possible outcomes, or two and then forks. The trial court may acquit the accused, exonerate the accused, in which case the process concludes, or the trial court may result in a verdict that finds that there is conduct requiring sentencing. And in that instance, the accused then has the choice, do I appeal? If they appeal, they go through that process. If they are unsuccessful on appeal, then they return to the bishop for sentencing. If they don't appeal, then the matter goes immediately to sentencing. Now, this is a good moment to mention that at any point in this process, a presbyter can voluntarily submit to discipline, can confess to offenses, and allow the bishop or the bishop's delegatee or the ecclesiastical authority in the diocese to enter the sentence. So at that point, we've come out at the moment where there's sentencing. Following the sentence, the next step is that the diocese must give notice to the archbishop's office, to the provincial office, of the sentence that was imposed. And initially, that was simply a free-form requirement. At this phase, we have just added in the last couple of years an additional reason for that report. The canons now establish a provincial list that lists those clergy who have been found guilty of an offense. Part of the reason for that is to permit diocesan bishops and their chancellors to inquire and see if a clergy person they're considering receiving into their diocese is guilty of an offense that would be cause for concern. And obviously child protection issues loom the largest there, but there may be others. So under Title 4, Canon 10, you notify disciplinary action taken. That is resonant of Monty Python's old all England summarized Marcel Proust in 5 sentences or less. That is your rapid fire overview through the process. Let me pause here and Phil, send it back to you for our panel discussion.
Wonderful. Scott, well done. That is no mean feat to get through Title 4 in 15 minutes. So we are grateful. I've already received some questions about whether slides will be available, and the answer is yes. We will make both Scott's slides and the wonderful decision tree that Chancellor Jeff Garrity has done for us available to you, as well as the other slides that have been presented today. We are